afternoon, everyone. Today, I will be presenting on two important areas of criminal law, the offense of murder and the doctrine of private defense. These two topics are closely connected because while murder represents a grievous offense against life, private defense provides a lawful exception when force is used to protect oneself or others. Murder is universally recognized as the most serious crime with severe consequences for society. Section 300 of the Malaysian Penal Code defines murder as causing the death of other person with the intention to kill, to cause bodily harm, or with knowledge that the act is likely to endanger life. For a conviction, the prosecution must prove both actus reus, the unlawful act of killing, and mens rea, the guilty intention. This principle is captured in the maxim actus non facit reum nisi mensit rea, meaning that an act does not make one guilty unless the mind is also guilty. The punishment under section 302 is the death penalty, reflecting the seriousness of the offense. Globally, intentional homicide remains a major concern with around 500,000 deaths recorded every year. Beyond the act itself, post-homicide practices such as hiding or destroying evidence are also criminalized. Section 201 of the Penal Code makes it an offense to conceal evidence, punishable by imprisonment and fines. This shows that murder is not only a legal issue but also a social one affecting public safety and trust. In our research, we analyzed roughly 50 cases between 1965 and 2025 to understand this impact. Alongside the offense of murder, the law also recognizes the right of private defense. Section 96 to 106 of the Penal Code provide exception to criminal liability. Section 69 states that no act is an offense if done in the exercise of private defense, making it a complete defense. Section 97 divides this right into two categories, defense of person and defense of property. Defense of person allows protection against personal attack, while defense of property applies in the cases such as theft, robbery, mischief, or housebreaking. This right begins when there is a reasonable apprehension of danger. Section 102 for person and Section 105 for property, and lasts only as long as the danger continues. Section 100 and 103 even extend the right to cause death in the extreme circumstances such as threat to life, grievous hurt or assault with intent to commit rape, kidnapping, or wrongful confinement. For property, this includes theft, housebreaking, or fire. However, Section 101 and 104 emphasize proportionality. In other cases, only lesser injury may be caused. Section 99 further limits the right, stating it cannot be used when there is time to seek public authorities or against act of public servants acting in good faith. Finally, Section 106 introduced the principle of necessity, allowing private defense even if it may unintentionally harm an innocent person. Courts apply both subjective and objective tests, whether the accused genuinely perceived danger and whether a reasonable person would agree.
Next, for the literature review, I will discuss on how scholars and courts have analyzed the defense of private defense, especially when it is raised in murder cases. Generally, private defense is recognized under Section 96 to 106 of the Penal Code as a complete defense to criminal liability. However, many scholars agree that although this right exists, it is not absolute, particularly when the outcome involves the death of another person. Firstly, Muhammad Yunus and Muhammad Ismail explained that private defense is strictly limited by the principles of necessity and proportionality. According to their analysis, the use of force, including lethal force, is only justified when the accused reasonably believes that there is an imminent threat of death or grievous hurt, and when no other reasonable option is available at that time. Importantly, they highlight that courts apply both a subjective test, which look at the accused's genuine belief, and objective test, which consider whether a reasonable person would have acted the same way in that situation. This explains why Malaysian courts often reject private defense claims when the response is excessive, such as in public prosecutor against Ngumbang aka Abang. Next, Muhammad Safri, Muhammad Naim and other scholars focus on the burden of proof. They point out that once private defense is raised, the accused bears an evidential burden to prove it on a balance of probabilities. This is supported by cases like Asis bin Lako against public prosecutor, where the defense failed due to the inconsistent statements and lack of supporting evidence. These studies shows that merely claiming self-defense is insufficient without objective proof such as medical or witness evidence. Another major theme in the literature is proportionality. Uwe Steinhoff argues that proportionality must be assessed based on the specific facts of each case rather than through rigid rules. Malaysian courts reflect this approach by rejecting private defense when violence continue after the danger has ended, as seen in Pendakwa Raya against Ye Wei Liang. On the other hand, courts have accepted the defense where the threat was immediate and the response was limited to what was necessary, such as in public prosecutor against Mu Hee Hong. Additionally, Yang J. Lee explained the proportionality in self-defense concerns liability rather than punishment. This helps clarify why courts focus on whether the deceased had made themselves liable to the defensive force. If the threat was real and serious, the accused may be fully acquitted. Finally, recent studies also highlight the need for a contextual approach, especially in cases involving psychological factors. For example, in Nisalma binti Sa'ad against Pendakwa Raya, the court accepted expert evidence on battered woman syndrome, showing a more nuanced understanding of reasonableness in private defense claims. Thus, the literature shows that while private defense is legally recognized, Malaysian court apply it very cautiously. The consistent emphasis on imminence, necessity, proportionality, and evidence explains why most private defense claims in murder cases are ultimately rejected.
My name is Firdaus, and today we will be diving into a complex area of law, the defense of private defense in relation to murder under Malaysian Penal Code. We'll explore how the law attempts to balance the right to life with the necessity of self-preservation, examining when taking a life can be legally justified. The doctrine of private defense, whether is it justifiable homicide. Firstly, the key condition is that reasonable apprehension of danger, genuine belief of imminent threat of death or grievous hurt. And what do we mean by imminence of threat is that immediate danger, not retaliation, and no legal recourse, opportunity to seek protection from authorities. And finally, proportionality of response. Force used must be reasonably necessary to repel the attack. Excessive force negates the defense. Next, to determine whether private defense applies, the court undertakes a dual assessment, examining both the subjective belief of the accused and the objective reasonableness of that belief. The court asks, did the accused honestly believe they were in danger? This involves examining their state of mind and the circumstances as they perceived them. But that's not enough. The court must also determine whether that belief was objectively reasonable. Would a reasonable person placed in the same situation have perceived a similar threat? In essence, the belief must be both sincerely held and rationally justifiable. So, in conclusion, we can say that the defense of private defense provides a potential justification for homicide, but it's a justification that's carefully scrutinized by the courts. The court must balance the accused's right to self-preservation against the sanctity of human life. The key lies in the court's assessment of the accused's belief in the face of imminent danger. If the belief is both honest and reasonable, the accused can be acquitted, underscoring the fundamental principle that the right to life includes the right to defend it. Thank you.
Next, we move on to the statistical analysis of the cases. So in our findings, we also prepare the statistical analysis on the applications of the defense of private defense in the cases of murder. So these statistics include the number of private defense raised and the cost of murder. So this graph shown use simple pie bars charts to break down private defense claims under Malaysian Penal Code sections 99 to section 1106, ranging from year 1965 to 2025. So from the pie chart, a massive 72% lies limiting for outright rejections of private defense claim and leaving 20% of partial success. The court approached these pleas under Penal Code section 92 and 67. For instance, in public prosecutor against Ngumbang AK Abang 496. From the pie chart, we break down the sections of private defense from 96 to 106 of Malaysian Penal Code, ranging from year 1965 to 2025. Moving on to the next graph, based on the graph above, it shows the analysis of private defense claim rejection under Malaysian Penal Code that reveal 4 dominant factors as the number of excessive force that has 16 cases, no imminent threat 8 cases, continued attack after danger that collect 5 cases, and lack of evidence that collected 5 cases. According to the court judgment, the cases that got rejected, the accused respond exceed the necessity required to avert the harm, and 16 cases collected equal to 57s collected from the data due to excessive force. The case of public prosecutor and Ngumbang AK Abang and another appeal, the High Court rule overkilled negated the plea, and Pendakwa Raya against Yu Wei Liang rejected the post-threat vehicular ramming. And in the case Muhammad Rizwan Gan bin Abdullah against public prosecutor found that the disproportionate force unjustified. Next, for the case Muhammad Yushari bin Saidin against public prosecutor, the court held prolonged assault impermissible. And for the case Atiran against public prosecutor, court rejected the private defense claim under Penal Code Section 99 as the appellant delivered repeated hammer blows to the deceased as he had already passed out. And other cases that exceeded the limits of necessary force, such as Guy Boon Leong against public prosecutor and another appeal, Hai Tong Sia and another against public prosecutor, and Khairul bin Nordin against Pendakwa Raya. Next, 8 cases collected that have no imminent threat equal to 29%. The court rejected private defense under Section 99 to Section 106 due to the accused failed to establish reasonable apprehension due to immediate death and unjustified action. The case we can see is Aziz bin Lako against public prosecutor was rejected due to inconsistent statement, failing balance of probabilities, and no evidence of the threat. For the case, public prosecutor against Kong Chai Han against public prosecutor against Basri bin Takdi, Pendakwa Raya against Johanizam bin Johari. These cases were reported due to no imminent danger proven and excessive force rendered Section 96 to 106 implicable, and the defense failed on probabilities. Next, 5 cases were reported where the court rejected private defense under Penal Code Section 99 because the accused persisted with violence. Salahuddin bin Ora against Pendakwa Raya Liu Yuwing Liang. These are the cases where court judgment found deliberate wounds inflicted and disproportionate and murderous intent. While for case Stephen Lagang against public prosecutor, Abois Eki Sanan and against public prosecutor, and Stephen Lagang against public prosecutor, these were cases that also rejected the same factor. For example, in case Abois Eki Son against public prosecutor, the appellant failed to discharge the burden to prove it on the balance of probabilities. So the accused bears evidentiary burden for private defense and inconsistencies in statement claim. Lastly, the factor that were court rejected private defense as defense that the accused failed to discharge the evidentiary burden on balance of probabilities and lucky witness. This could be seen in the 5 cases which are Odangs against public prosecutor, Al Sarid bin Amboms against public prosecutor, and Angsa Akegari against public prosecutor. Another 2 cases that I already mentioned but also have the same factor, which the failure to prove to establish the private defense and inadequate proof which are public prosecutor, Basri bin Takdi and Aziz bin Lako against public prosecutor. Another cases reported that being rejected by court are Pendakwa Raya against Muhammad Azwan bin Zulkarnain, Tony Akebel Yang against Pendakwa Raya, and public prosecutor against Chow Cheng Kong. And these 3 cases High Court exemplify rejection for no imminent threat. Pertaining to the case Pendakwa Raya against Muhammad Azwan bin Zulkarnain, the court rejected the self-defense after forensic evidence and witness testimony and medical evidence showed excessive force beyond what was necessary when undermined the defense. In next statistical analysis, we also provide the data of murder cases with the defense of private defense per year to show the distributions. So based on the graph, there were 2 cases reported in the period between 1965 to 1975, followed no cases in 1975 to 1985, and 0 cases reported again in 1985 to 1985. A noticeable increase suggests a growing tendency among accused person to rely on private defense as a legal argument in murder trials. Thus, the most significant rise is observed in the period 2005 to 2015, and 9 cases reported, and the highest number of cases reported between 2015 to 2025, which were 32 cases. So the number of cases reported each year shows that the crime of murder always occurs even with only 0 cases per year. Furthermore, the accused tried to use private defense to avoid their liabilities, which indirectly can influence other persons to do so.
This pie chart shows the distribution of private defense cases by court level. This chart is divided into 2 segments, the High Court and the Court of Appeal. From the chart, we can see the High Court account for 33 cases, which form the larger portion of the pie. This indicates the most private defense cases are decided at the High Court level, where evidence and factual findings are primarily assessed. In contrast, the Court of Appeal accounts for 70 cases, representing a smaller portion of the chart. This suggests that fewer private defense cases proceed to the appellate level, usually because only cases involving errors of law or significant issue are appealed. Overall, the chart demonstrates that private defense claims are more commonly determined at the High Court level, with a smaller number reaching the High Court of Appeal. This reflects the hierarchical structure of the court system and the limited scope of appeal in criminal cases. This pie chart shows the distribution of private defense cases by court level. This chart is divided into two segments, the High Court and the Court of Appeal. From the chart, we can see the High Court accounts for 33 cases, which form the larger portion of the pie. This indicates the most private defense cases are decided at the High Court level, where evidence and factual findings are primarily assessed. In contrast, the Court of Appeal accounts for 70 cases, representing a smaller portion of the chart. This suggests that fewer private defense cases proceed to the appellate level, usually because only cases involving errors of law or significant issue are appealed. Overall, the chart demonstrates that private defense claims are more commonly determined at the High Court level, with a smaller number reaching the High Court of Appeal. This reflects the hierarchical structure of the court system and the limited scope of appeal in criminal cases. This graph illustrates the effectiveness of private defense claims in court based on the outcome of decided cases. On the horizontal axis, we can see three possible judicial outcomes when private defense is pleaded, which are accepted, rejected, and also punishment reduced. The vertical axis represents the number of cases. First, looking at the accepted category, there are 14 cases where the court fully accepted the plea of the private defense. This means the accused was acquitted because the court was satisfied that all legal requirements of private defense were met. Second, the reject category shows the highest number with 35 cases. This indicates that in the majority of cases, court rejected the private defense claim, usually because the force used was excessive, unnecessary, or not proportionate to the threat faced. Lastly, there's only one case where the private defense was not fully accepted, but the court reduced the punishment. This suggests that although the defense failed, the court still considered the accused action as partially mitigating. Overall, the graph demonstrates that private defense is difficult to successfully rely on in a court. While it can lead to acquittal in some cases, courts apply the doctrine strictly, and most claims are rejected unless the legal conditions are clearly satisfied.
Assalamualaikum and a very good evening. A study analyzing 50 murder cases in Malaysia between 1965 and 2025 has identified persistent challenges in the application of private defense. The findings indicate that only 28% of cases were partially successful, while the other 72% failed, demonstrating that the burden of proof rests heavily upon the accused under sections 96 to 106 of the Penal Code. The courts have consistently maintained the clear and credible evidence of an imminent threat is required. In the case of Public Prosecutor and Ngumbang Abang from 2024, the High Court dismissed that the appeal on the basis that the force used was disproportionate. Similar principles was applied in Pendakwa Raya and Yu Wei Liang from 2023 and Muhammad Yushairi bin Saidin and Public Prosecutor from 2020, where the accused's actions were found to exceed the principle of necessity. This decision reaffirms that private defense will not be upheld where conduct goes beyond what is reasonably required for protection. The study further recommends the formulation of clear judicial guidelines, including a standardized test assessing imminent threat, proportionality, and defensive intent. It further emphasizes the importance of public legal education to address the widespread misunderstanding of the limits of private defense. Such measures are essential in order to ensure consistency, accountability, and sustained public confidence in the criminal justice system, especially in Malaysia. Thank you very much.